So as you've listened in, I suppose, what are your recommendations for how some of this can be built into the technical side of DPI, these essential elements, the essential attributes of what we're speaking about as the just information architecture, if we want to realize these outcomes from DPI?
Thank you. Thank you, Priya. Thank you for the question and also the invitation to be on this panel, and to the panelists before me. So I have this tough challenge of having little time and being the last one to kind of try to bring everything together. But we were thinking, I speak from an organization that is based in Brazil and is doing local and global work to promote fundamental rights in the face of datafication processes. And we were acquainted somehow with this idea of DPI as a framing and as a definition, and that it is disputed also around the time of the transition between the G20 in India and the G20 in Brazil, which took place last year. And we were asking ourselves, I think, some of these same questions, like some more conceptual, or what are we talking, and some more normative, what is the public in DPI, what should it be? And I think what I heard a lot about the word integration and integrating frameworks. And we have been attempting, based on the Brazilian context, where we have fundamental rights to data protection and a very lively current landscape of both legal and institutional movements to kind of give life to this right and to this framework, how that can also be integrated to the discussions of DPI, because I think our hypothesis was that this grammar of data protection was not duly integrated to the discussions of data governance when it comes to DPI. So what we had already at that point had some research and policy work on risks of digital identity systems in the Brazilian context. And those were risks arising from data processing specifically, but also broader risks of discrimination, exclusion. I mean, I think we all know what we're talking about here. But basically, I think our concern was to not frame the problem of data-related risks of ID and of digital infrastructure only in terms of privacy, but rather understanding how data protection as a procedural right that has certain mechanisms to be implemented, that already involves a whole number of actors that need to be accountable, how that can be better integrated into the discussions of first identity as a backbone of DPI, but also now with the DPI framework. So more recently, we produced this new report that kind of seeks to propose that integration. Of course, it is very it considers the Brazilian legal institutional framework for data protection, but we understand that there is a lot of it that is relevant elsewhere. And I think it goes back to the idea that while privacy is substantive, the idea of data protection really starts from the idea that personal information will circulate and should circulate, and it provides the rules and the constraints to ensure that this information flow is just and protects fundamental rights, including privacy, but also other fundamental rights. So we think that this is relevant because we think that it provides a bridge to concerns about trust, that not being formulated only in terms of trustworthiness of systems, but rather from a relational perspective that centers people, that centers their rights, and that creates mechanisms to ensure transparency, accountability, and redress for people. So from this particular context, and from this particular read on DPI, the report comes to a few conclusions and attempts to articulate these ideas. I will briefly share them. I know we have very little time, but it starts really addressing the public value in DPI as a condition for it, and that data, economic value being generated by data, regardless of how that is shared, does not per se guarantee the achievement of public value if the rights of people are being neglected. And that informational autonomy and self-determination at the same time that it ensures that individuals are able to exercise their capacity to develop their personalities, but also to know how their data is being used. It also can generate collective value as it creates more trusting people and also trustworthy databases, and even can act as barriers to fraud and identity theft when you have that kind of relationship being established, and using those concepts from data protection and those ideas of self-determination. We also talk about privacy as contextual integrity. I think this is also important to kind of bring into the discussion. This is very confined usually to data protection scholarly circles, but we think that it makes sense in the context of DPI as well. And the informational separation of powers, the idea that at least on the state side of things, there needs to be also administrative oversight and certain mechanisms to make sure that the sharing of data is also not creating more concentration of power on that side of the equation. And finally, there are also some discussions on accountability mechanisms and the idea that data protection is already containing a preventive and sometimes a precautionary principle, and accountability mechanisms such as assessments and things that could also be looked at in terms of being updated and being adapted to the context of DPI, but that we think it really should not be taken for granted. And I think the idea is that sometimes you have this notion that data protection is solely related to privacy, or that it is very individual. But what we try to kind of stress here is whether that framework also can be further assessed in terms of its public value creation. So what we have attempted to do in Brazil recently was that, and I will stop here so that we have some time for questions. Thank you.
Thanks so much, Mariana. And I think everyone's wondering when they can get access to that report or read it. And certainly I am very keen to read it. But thanks for that. And what was really interesting was that you were speaking about embedding the rights frameworks, even in the information flows, and speaking about, I suppose, beyond privacy by design, you know, what comes next in terms of these real mechanisms of accountability. And you spoke about autonomy and self-determination, and I think that goes back to what Thomas was describing as the social contract. If we want people to show up, then you know, how do we deliver on the value that was initially promised?
I want to now go to Dr. Jaqueline, who is here with us. And Dr. Jaqueline, if you would spend the next 1 minute to introduce yourself, and then I will do a question for you.
Of course. Thank you so much for having me. My name is Jaqueline Pigatto. I'm with Data Privacy Brazil, a Brazilian NGO working with digital rights in Brazil and also in the Global South. It's a pleasure to be here. Although I'm not a lawyer, I'll try my best to address your question.
Thank you so much, because we are a multi-stakeholder driven body of the United Nations, the IGF. Now I received the order from the judge for every speaker to stay within 5 minutes. Thank you, Professor Swear, for staying within 5 minutes. It was actually around 3.43 minutes. Now, Dr. Jaqueline, with the rise of things like spyware, the state surveillance tools being used in the name of national security, how should the judiciary respond when such technologies are used together with evidence? What role do courts play in safeguarding rights while navigating cases where surveillance methods themselves may be legally or ethically contested?
Thank you. I think I'm going to first bring the concept of spyware for those who are not familiar with. But I think most of us know by now that spyware refers to surveillance technologies used to secretly extract data from personal devices and networks, often without the user's knowledge and with minimal legal oversight. So while presented as legitimate tools in the context of national security or law enforcement, these tools are increasingly being used in ways that erode democratic institutions and legal protections. So their undetectable nature means that violations often occur in the shadows, beyond the reach of public scrutiny or legal remedy. And as highlighted by one of our projects in Data Privacy Brazil, the Digital Defense Initiative, spyware not only violates privacy, it undermines judicial integrity, due process, and the separation of powers. So in Brazil, we have the ABIN Paralela case that I think exemplifies this threat. First Mile, a spyware tool, was deployed by intelligence officials to surveil targets that ranged from activists to Supreme Court justices themselves. So it is a paradigmatic case that stresses the most salient features of this type of surveillance. But it's only one example in a broader context of lack of oversight. This incident reveals a structural problem. When surveillance happens outside transparent legal frameworks, courts are sidelined and unable to guarantee fundamental rights they are tasked to protect. And in the Brazilian context of use of spyware by the state, there is a Supreme Court case pending in which the regulatory gap that allows for the current state of things is being challenged as unconstitutional. In this case, we argued that the use of different spyware for surveillance by the state should be ruled unconstitutional, since even in possible legitimate context of criminal persecution and law enforcement, the nature of how they work and their affordances move way beyond traditional investigative methods, such as telephonic interceptions, taking advantage of vulnerabilities found in other platforms and networks, and resulting in a level of intrusion that is difficult to justify under democratic parameters. However, even if the entire system is not ruled unconstitutional, we are requesting that strict criteria be established for the use of spyware, analogous to the existing regulations for other cases of breach of confidentiality, particularly the requirements of prior judicial authorization and adherence to similar strictness as in other situations of confidentiality breach, the constitutional interpretation of communication confidentiality updated to contemporary standards of intrusiveness, the inclusion of mechanisms to respect the chain of custody, the individualization of subjects subjected to intrusion procedures, and the development of other parameters compatible with the constitutional order. So I'll stop here now. Thank you.
Thank you, Dr. Jaqueline. That was very informative, and I'm very glad that you could do this submission. I know you are not a lawyer, but we are all, in some way or somehow will be ending up in court. So what would be your suggestion or recommendations on spyware? If you could spend like 1 minute to respond to that.
Sure, thank you for the question. We have in our project, Data Privacy Brazil, we are developing some key recommendations on the research. And just to also clarify that I spoke about the Brazilian case, but we also, this is not an exclusivity of Brazil. We have cases in Colombia. We have a very important precedent in the US with the Pegasus and the ruling ordering to damages to Meta. But yeah, let me say some recommendations we are working on in terms of, I think we have 4 recommendations, key recommendations, I would say. The first one is to develop technical and legal standards for the digital chain of custody, including metadata preservation, access logs, authentication layers, and independent audit trails. The second one would be train judges and legal professionals in cybersecurity, digital forensics, and especially data protection. The digital knowledge gap within our courts is a risk we can no longer afford in this scenario. The third recommendation would be to equip courts with cybersecurity protocols and contingency plans to strengthen institutional resilience against cyber threats, including unauthorized access to judicial data. And last but not least, of course, promote multi-stakeholder dialogue among courts, technologists, civil society, and policymakers. I think judicial systems must evolve collaboratively to meet these realities we are talking about here. So,
today we have participated in this judging in the digital era, cybersecurity and digital evidence. If you look at the way you have interacted with the audience, the questions that they have brought to the panelists, what will be your parting shot today?
I think, and I'm going back to Brazil because it's the context that I know. In Brazil, we have the right to data protection as a constitutional right. This happened in 2022, and I think it was a great victory. We also have a comprehensive general data protection law we call LGPD that is in place, also with an independent data protection authority. But we still don't have a criminal data protection framework. So I think that's an important gap to address. And I think all of the questions and discussions that we raised here today could share this concern of having this framework to fight against privacy-related crimes and also these weaknesses of the judicial system, their ability to handle cybercrime effectively. So this gap in Brazil has been identified and debated in some legislative reform efforts, including the reform of the Brazilian Code of Criminal Procedure and some specific advocacy efforts, but no law has been approved so far. So I think that's one development that we still have to fight for.
Thank you, Dr. Jaqueline.